I would like to thank Professor Barrister for inviting me to give this short video clip for the 38th International Symposium on Economic Crime, which has been postponed to 2021. My name is Dr. David Chaikin. I'm chair of the Business Law discipline at the University of Sydney, where I teach a postgraduate course in international financial crime. This course, which I crafted in 2014, has become very popular, with 740 students taking the course last semester. Prior to my academic career, I was a litigator, specializing in international asset recovery and anti-money laundering. My former posts include International Law Enforcement Branch Head in the Australian Attorney General's Department and the Senior Fraud Officer at the Commonwealth Secretariat, where I worked with Barry. I spoke at the inaugural Cambridge Economic Crime Symposium back in 1982, while completing my thesis on regulation of corporate fraud as Barry Ryder's first PhD student. The theme of the conference was comparative securities laws enforcement and the vexed problem of insider trading, which the UK had just criminalised. Interestingly, at that time, the UK had rejected an invitation from the Swiss government to negotiate a mutual assistance criminal treaty. Consequently, international cooperation in combating insider trading was stalled. This became an underlying foundational idea of the symposium: the importance of expanding criminal justice cooperation between different legal and political systems. It was Barry who championed this idea by creating an international network devoted to meeting the scourges of organised economic crime. Since 1982, the symposium has dramatically expanded, not only in the number of participants, but also in the breadth of topics. There is no other international conference which attracts such diverse and influential participants: regulators, policymakers, bankers, and academics from nearly every continent. In the past 38 years, I've attended nearly all the symposium, except those which clashed with the birth of my daughters. I keep on returning to Jesus College because I enjoy the camaraderie of old and new friends and the intellectual debates. I would like to talk about whistleblowers, a topic which I was invited to contribute at the now postponed conference. Why are whistleblowers significant in the public discourse on financial crime? Firstly, whistleblowers are critical to the detection of financial crime. A study by the Association of Certified Fraud Examiners, based on nearly 1,500 cases from over 100 countries, showed that 40% of corporate fraud cases were detected by tips from whistleblowers. This means that whistleblowers are far more significant than management, audit, or law enforcement in the detection of financial crime. Without whistleblowers, the secrets of financial criminals would remain hidden. Secondly, it's unconscionable that whistleblowers are not given adequate protection against powerful wrongdoers. Sadly, the history of whistleblowing is one where individuals suffer from their disclosures through reprisals directed at themselves, their families, and friends. Unless whistleblowers are protected and made safe, then society will remain unsafe from financial criminals. My thinking on whistleblowing has been heavily influenced by my experience as a member of an expert advisory panel appointed in 2017 by the Australian Minister for Revenue and Financial Services. One of the findings of the expert panel was that the 2004 statutory regime in Australia for private sector whistleblowing was ineffective. In practice, whistleblowers could not rely on the law, and not one corporate employer was prosecuted for criminal retaliation against a whistleblower. There was a huge gap between the promise of the law and the actual reality faced by whistleblowers. In 2019, the federal parliament passed amending legislation enhancing private sector whistleblower protections. The act removed key obstacles to whistleblowers obtaining protection, such as allowing anonymous disclosures and including former employees. Most importantly, the legislation altered the balance of power between whistleblower employees and company employers. In a world first, the legislation created a right of a whistleblower to sue their employer for compensation based on a corporate failure to prevent whistleblowers suffering detriment. Large companies are required to design and implement effective whistleblowing policies, processes, and controls. This will entail changing corporate culture so that whistleblowers are viewed as a positive asset, not just by senior management, but at all levels of the corporation. Whistleblower legislative reforms is now happening in a large number of countries, not just Australia. The digital world has also created a new type of whistleblower who hacks, steals, or leaks thousands of documents concerning the secret offshore financial dealings of the elite. In a number of these cases, the whistleblowers have been anonymous. More than 4 terabytes of data involving nearly 800,000 offshore companies, trusts, and foundations in 200 countries have been exposed. This vast treasure trove of information has been used by journalists to write powerful stories about corruption and money laundering. Governments have raised hundreds of millions of dollars in taxes from offshore tax evaders. Big data analytics have been critical to these outcomes, with an Australian fintech company called Nui supplying the software to review and analyze this massive human-generated data. This new whistleblower paradigm is significant, and it paves the way for the destruction of offshore bank and corporate secrecy, which have been the biggest obstacles to the detection, investigation, and prosecution of transnational financial crime. There are difficult public policy issues that will need to be addressed in this new age of big data. How are we to resolve the conflict between the right to privacy and law enforcement's need for maximum information to combat serious financial crime? How do we regulate the vast growth in data and its monetization, which is the essence of the business models of companies such as Amazon and Google? These are some of the questions that I am sure will be dissected, discussed, and perhaps even solved at future Cambridge conferences. I would like to thank you for your attention, and particularly to Barry and his team that have made this symposium so successful over the past 38 years.